not saying there are.
What has to be done, I would say, but whether it could be done or not.
No, not could
meet
be.
the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. This was a pure political act. And you circumvented the provisions of the Constitution to reach a particular end result, which you always wanted.
That's the second part is that, which you will argue, of course, that the
Yeah.
process by which they followed was.
Yes. Well, that is the issue before you. There's no other issue before you.
According to you, this could have been only done on the recommendation of the Constituent Assembly.
Yeah.
Absent a Constituent Assembly, you cannot exercise the power to abrogate.
Number one. Number two, in any case, it is they who believed that this could only be done through the Constituent Assembly. Apart from the fact that I say that it could be done, they also believed that it could be done, and they followed that procedure. Now, whether that procedure was right, was wrong, is for your lordships to decide. Whether there is another way to do it is something that they will decide. That's all that I can say. I don't want to make the argument in a hypothetical argument, conjuring up issues that don't arise in this case. And I don't want to give a helping hand as my learned colleague wants to do, because he can do it outside the court.
The lighter side, you said if you had to do it, you would do it a different way.
Maybe. But you can't introduce a bill in Parliament at 11 o'clock, pass a resolution without anybody knowing about it. Of course, those are internal procedures.
Of the Parliament.
I'm not saying anything.
212.
Yeah, so I'm just saying, 11 o'clock, nobody knows. Nobody knows.
Larger issue, as a member of Parliament, you will say, don't touch us.
Yes. That's right. So I'm not touching that process either. I'm only saying that this is what, it sort of fits into the argument that this was a political process carried through certain constitutional means, which unfortunately were not available.
Always a political process, Mr. Sibbal. Only question is whether it is within the constitutional means or not.
That's right.
Everything is a political process.
No, I'll tell you how, Manoj, because now let me just go through Coelho and then I'll go back to the list of dates.
Yes.
Volume 3.
You want us to read what now?
Volume 3, Manoj. Page PDF 323. And the fact of the matter is, Manoj, apropos what my learned friend said, almost all the laws applicable in the Union of India were applicable in Jammu. As of today, Manoj, I have a list, it runs into, pages after pages. Everything has been adopted, apart from other than the residuary power. Everything is adopted. Everything. It's like 100 and...
You are referring volume 3?
Yes, volume 3. Volume 3, PDF 323. Case law volume 3. Yes.
No, there is a separate volume for
Case law volume.
Yes, sorry, Miller. Case law volumes. Yes. It's Coelho, Miller.
Coelho and Rameshwar Prasad, they are in one volume.
Yes, leading Coelho, para 54, PDF 323. 323. Running page 776, Mother. Yes. 323, para 54. And remember this, if you use 368, you will have to have 2/3 present and voting. So you don't use 368 because you don't get present 2/3 present and voting. So you go through this procedure. So the question whether 368 could have been used or not is a separate issue. And had that been used, we'd have had another argument here, but it's not an issue here.
Yes, Mr. Gandhi. Which
I'm
is
just
the,
telling you
which
the
is the
hurdles
para
in the
from Coelho that you would like us to see?
Yes, para 54.
At page?
Page 776, Miller's PDF 323.
Page 323.
Yes. The distinction is drawn, my lord has that paragraph? By the author between the making of a constitution by a constituent assembly, which is not subject to restraints by any external authority, as a plenary lawmaking power and a power to amend the constitution. A derivative power derived from the constitution and subject to the limitations imposed by the constitution. No provision of the constitution framed in exercise of plenary lawmaking power can be ultra vires because there is no touchstone outside the constitution by which the validity of provisions of the constitution can be adjudged. The power for amendment cannot be equated with such power of framing the constitution. The amending power has to be within the constitution and not outside it. Why? Because you're subject to the constraints of the constitution. So you want to amend, you can use 368, but then you have to follow the procedure under 368. But so, for example, if you were to say that you amend the definition and say the provision for consent of the states is not required. Approval of the states is not required. Can you do that? The answer is no. That's a proviso to 368. So if you want to work within the Constitution, you have to follow then what the Constitution obliges you to do constitutionally. If 368 were available.
All right, apart from Coelho, which is the next?
Yes, next is para 118 of Coelho itself.
PDF?
PDF page 344. We have I'm sorry, para 180. We have earlier noted that the power to, my lords have that?
Para 118.
Yes. We've earlier noted that the power to amend cannot be equated with the power to frame the Constitution. The power has no limitations or constraints. It's a primary power, a real plenary power. The latter former power, however, is derived from the former. It has constraints of the document, that is the Constitution which creates it. This derivative power can be exercised within the four corners of what has been conferred on the body constituted, namely Parliament. The question before us is not about the power to amend Part 3. As per Keshamnan Bharti, power to amend exists in Parliament, but it is subject to the limitation of the doctrine of basic structure. The fact of validation of laws based on exercise of blanket immunity eliminates Part 3 in entirety. Hence, the rights test as part of the basic structure doctrine has to apply. So, Malats, therefore, we are now left with a Parliament which seeks to amend 370. So therefore, it has to work within the constraints of the Constitution. That's what we're concerned with. We're not concerned with any other interpretation of the Constitution. So now we go back, Malas, to the list of, yes, the Ambedkar statement is volume, yes, document volume 8, PDF page 26. Yes. Volume 8, documents volume 8, PDF page 26. Let's quite frankly,
PDF page?
26. Just two paragraphs and then I'm done with this issue altogether, Manoj. PDF page 26.
Documents volume.
Documents volume 8.
Eight.
You also have it? May I read it, Manoj?
Page?
Page 26, paragraph starting the provisions relating to amendment of the Constitution. My Lord Justice Surikant has it.
Yes.
And Lord Justice Cole has it.
Yes, yeah, fine.
The provisions relating to amendment of the Constitution have come in for a virulent attack at the hands of the critics of the draft Constitution. It is said that the provisions contained in the draft make amendment difficult. It is proposed that the Constitution should be amendable by a simple majority, at least for some years. The argument is subtle and ingenious. It is said that this Constituent Assembly is not elected on adult suffrage. Well, I've read this. This part of it I've read.
We actually read it from just Jagannath
So
Reddy's.
let's leave that. Come to the next paragraph.
Sorry, again.
What is said to be the absurdity? That paragraph, next paragraph.
Yes.
What is said to be the absurdity of the amending provision is founded upon a misconception of the position of the Constituent Assembly and of the future Parliament elected under the Constitution. The Constituent Assembly, in making a Constitution, well, that also I've read. So this is the exact.
There's only one part in Dr. Ambedkar's statement is very prescient. Dr. Ambedkar postulates that a future Constituent Assembly may be a future Parliament itself.
Yes.
Says the future Parliament, if it met as a Constituent Assembly,
Yes.
its members will be acting as partisans, seeking to carry out amendments to the Constitution
Yes.
to facilitate the passing of party measures which they failed to get through Parliament by reason of some article of the Constitution, which has acted an obstacle in their way.
This is
That
the
difference
precise
between the
argument.
Constituent Assembly and the future Parliament.